The MTA, New York City Transit, has reduced service on the C and the F lines to the detriment of our members in the TWU, as well as the riders and communities served by the C and the F lines. So as a union, we've been waging this fight for ourselves as well as the riders. And the next step in that fight is a lawsuit, which we brought this week against the MTA. We have our counsel here, Mr. Arthur Schwartz, and I'll let him say a few words about the legal aspect of that.
So, we brought this lawsuit on behalf both of the union, Mr. Logel as a subway rider, as well as the Fulton Houses Tenants Association, which is a NYCHA tenants association that's on Fulton Houses, runs between 16th and 19th Streets. I got a lot of calls from reporters this morning, and the issue, what people say to me, hasn't service been reduced? Why is this anything different? So what has happened here is that the authority had allowed the employees to pick based on a full schedule. They had them pick that way in November, so that if they restored service, there would be employees available to do the train operator and conductor jobs that are necessary to run the trains. The F train was cut by 36 runs. That's 36 runs, meaning from the beginning to end and back to the beginning.
Out of how many?
I don't know, how many?
A little over 100.
Okay, so a third of the runs. It's increasing the time between trains between 8 and 12 minutes, and it also means that there's more people per train. Everyone understood during the pandemic, when the subway ridership was down, that that service was cut, and the employees, although they picked those jobs, understood that they could get, if their run wasn't going, they could get assigned to whatever work that was needed. They just had the employees, over the union's objection, pick a new schedule that reflects a permanent erasure of those 36 runs. There will not be employees available to, if they ramp up the runs, to take over those trains, drive them, and act as conductors. So this reflects a decision by the Transit Authority to make permanent cuts in the F train and also in the C train. The C train is about 8 runs, but in the F train it's 36 runs. There is a provision in the Public Authorities Law that makes it, it basically says that the New York City Transit Authority isn't a free agent to make these kind of cuts. It says that the New York City Transit Authority, before making the cuts, has to give 30 days notice to the mayor, and it also has to give, the law says they also have to give 30 days notice to the Board of Estimate, whose powers were assumed in 1989 by the New York City Council. So our position, and then the City Council had a right, under the law, to ask for public hearings. So what the authority has basically done is, they've moved into a permanent cut of these runs. They haven't given notice to the mayor, they haven't given notice to the City Council, and they have not allowed the opportunity for the public, or the City Council first and then the public, to weigh in on the necessity of these cuts. What's utterly bizarre about this is that subway ridership is up. Every day in the last week, subway ridership reached a new peak post-pandemic. So although subway ridership is still down from where it was in February of 2020, people are coming back to the subways. And it's odd that you cut service just as people are coming back to the subways. It's also, it runs contrary to what the authority has been telling everyone. The authority has said, we are not cutting any service. They have said they got all the money they wanted from the stimulus package, but they're cutting service and hope that nobody would know about it. So the union is basically not only making it known, but we've gone to court, and the permanent cuts are supposed to go into effect on Sunday, the 21st. We hope to be in front of a judge tomorrow to get a temporary restraining order to keep them from putting those permanent job cuts in place. And then we'll litigate in front of that judge about whether they can do this without sending that appropriate notice to the mayor and the city council and giving the city council the opportunity to demand public hearings.